Feel free to correct it. Hey everyone, welcome to another episode of Darshan Talks. I'm your host, Darshan Kulkarni. It's my mission to help you trust the products you depend on. As you may know, I'm an attorney, I'm a pharmacist, I advise companies with FDA-regulated products. So if you think about drugs, wonder about devices, consider cannabis, or obsess over pharmacy, this is the podcast for you. Both my guests and I are attorneys, so we do have to say this. This is not legal advice. It's not intended to be clinical advice either. I do these podcasts because they're a lot of fun, and I find myself learning something new each time. But it would be nice to know if someone's listening. So if you like what you hear, please leave a comment, please subscribe. And I know my guests would appreciate it, and I would appreciate it as well. If you like what you hear, please share. If you want to find me, you can always find me on Twitter at Darshan Talks, or just go to our website at darshantalks.com. Our guest today is the deputy director at the Sydney Institute of Criminology and adjunct lecturer, University of Sydney Law School. And that just sounds impressive enough to me. But add on to that, he is what most would call the preeminent thought leader. That's the word I was looking for. Preeminent thought leader around neurorights, and I'm really excited to ask him questions about that as well. So if you are in clinical research, if you are interested in neuroethics, neurorights, you probably care about today's discussion. Ladies and gentlemen, our guest for today, Dr. Alan McCay. How are you, Alan?
Good, thanks, and thanks for the very generous introduction. Thank you.
Well, it's all true. It's all true, especially on the internet, where I believe Abraham Lincoln said so. But having said that, I want to hear more, Alan. Like the last time we spoke, we did a kind of deep dive into neuroethics, and quite honestly, I want to do a refresh. I want to get into this a little bit more. But before we get into that, what I want to hear a little bit more about is the fact that I understand you are an adjunct professor at the University of Sydney. So you've had a pretty interesting life already. How did you land up with being a lecturer? And how does that tie into the work you do at the Institute of Criminology?
So I have practiced as a lawyer, but I always enjoyed the more theoretical aspects of law and reflecting on whether it's just and questions of that nature more than the practice, although there were some aspects of practice I enjoyed. And also I learned that as I moved into teaching, that I quite enjoy teaching. I enjoy interacting with students, and as I've progressed into all of this, I realized that I like research and writing, and the teaching and research suits me a bit better than practice.
But you are not, as evident from your address, from your accent, you're not from Australia, is that correct?
No, I'm originally from Scotland, and I did practice in Scotland with a sort of medium-sized firm in Edinburgh first, and then I moved to Hong Kong, and I practiced with Baker McKenzie as a commercial litigator for a while, and then in Sydney I've predominantly been in teaching and research, so I'm admitted in all those jurisdictions.
Do you find the principles of law to be similar between Australia, Hong Kong, and the UK because of the fact that the UK, it's often English law that gets applied?
Yes, I do. Although Australian law and the law in Hong Kong are both more similar to English law. Scots law is a little bit different.
Interesting.
So it's probably easier to retrain in Hong Kong or in an Australian jurisdiction if you came from England than from Scotland. But Scotland's not too bad, but it's just a little bit more different.
No, of course. If I was a betting man, I would have gone the other direction. I would have thought that Hong Kong law would be more different, or Australian law would be more different. But I love being surprised. Let me ask you a question. So, did your interest in neuro-rights start as early as your time in Scotland, or did it sort of emerge in Sydney itself?
it emerged in Sydney. I was initially interested in free will, the philosophical problem of free will. So when I was an undergraduate law student in Scotland at Aberdeen University, I learned of the philosophical problem of free will when I was studying criminology. And really, that interest has been something that stayed with me. And I did a PhD that was connected, that raised the free will problem. I looked at behavioral genetics and sentencing. And then I got into neuroscience and the law, which also seems to relate to free will. And then from neuroscience and law, got to neuro-technology and the law. And I started looking at neuro-technology in the criminal law. So, if somebody acts by way of brain-computer interface, if you think about the criminal laws, this actus reus, there's something odd about a brain-computer interface is mediated actus reus, because it's like an action without any traditional bodily involvement. And so I started to get interested in those questions. And then I connected with Professor Raphael Just, who's a neuroscientist at Columbia University in New York. And as a result of that and discussions with him and learning about what he was involved in, I started to think, well, actually the human rights aspects of this is quite important. It's not just criminal law doctrine, it's human rights that need to be paid attention to in the context of neurotechnologies.
So it's fascinating to say that. I have a bunch of questions that came out of just that little bit you gave. The first one that really came out to me, you talk about the free will problem. What is the free will problem?
So the free will problem, it appears in a number of forms. The one that I'm most interested in is sort of a secular form in which you imagine, if you imagine as that we're part of the world, we're made up of similar stuff as the rest of the world, including a table and including a rock. And we're acted on by natural forces, and yet we when we make decisions, we think we're free to do this way, go this way or that way, or choose this or choose that. And this sort of viewing of ourselves as part of the natural world and acted on by forces seems to throw that into question. In the context of criminal law, you might think, well, if you think about all the influences on a defendant or offender, if they've been convicted, they've got social influences, they've got biological influences about the way they're constituted, and things have happened to them. And once we start to think about all these things and the way that various other things have acted upon people, we start to think, well, are they really free? And if we think they're not free, then that seems to have consequences for punishment. In Australia, Hong Kong, Scotland, American jurisdictions, other jurisdictions, there's a retributive element to criminal law. And if people are not really free, if they don't have some kind of free will, well, then that draws into question whether criminal punishment is, or the retributive part of criminal punishment is justified. So it's a sort of philosophical problem that's also a problem for anybody who's concerned about, say, for example, the justification of criminal punishment. So that's kind of my interest on it, is the context of criminal punishment and thinking.
I love it. I have a couple of questions that come out of that. One of the things that is really gathering a lot of steam right now. Well, I'm gonna raise this point, and I'm gonna raise another point. You can combine them however you want. But one of the things that's really gathering steam right now is this idea of social determinants of health. Have you ever heard that term before?
Yeah, I have. Yeah.
Yeah. So, if you know what it is, I won't try explaining it to you. But for the audience, it's basically, as you know, the other factors that affect what your healthcare will look like. So, if you are a poor child in in one of the ghettos, you're unlikely to get the same opportunities to improve your health as a rich kid in the suburbs, which is very similar to the same concept you're talking about in terms of free will, which is you just have you have a different set of opportunities, and therefore your thought process and your access to opportunities is different. And that goes to your free will question, if you will. I guess that's my first thought, and my second question I guess my second thought that goes along with this is what you're describing is really tackling the retribution question, which is if someone got hurt, is it really my fault that you got hurt, or was I forced into that position? Was I backed into that position? Which is a very elevated sense of thought process, if you will. But doesn't that take away something from the person who actually got hurt? And what is your thought process as you analyze free will in that context? Should you only look at I guess if you start taking away this retribution element, does that place the person who was injured in a worse off situation, if that question makes sense?
I think that question it really underscores why it is the free will problem, because on the one hand you can look at it one way and you can think, okay, well, the offender was acted on by all these forces, and you can think about their life and the opportunities they had and their abusive father and their peers who were all gang members, and then you can start thinking, well, how free were they? But then you start thinking about the perspective of the victim. Maybe there's a victim who's got a disability or something as a result of some violent offending, and then you start to think, well, surely they deserve some punishment. And the difficult thing is that you're looking at the thing in these two different ways. We've left out the community at the moment. There's also community protection. But you're looking at the thing in these different ways, and they both seem right, but they can't both be right. And that's why it's the free will problem. You know, it's a problem because it's one of these long-running philosophical problems that last because it's so difficult. And there are various perspectives on it that all seem right, but can't all be right.
I love the topic. Let's sort of take that a little bit further, though, as I see it. You raised the issue of neuro-technology and criminology, if you will, and how you sort of went from the free will problem all the way down there, and really raised the question that we've always sort of talked about, which is as we start talking about cars coming into automated AI supplemented cars, if you will, coming onto the roads. We always talk about that problem, or AI supplemented trains. The problem of there are 4 people on one track and 3 people on the other, and you're going to send a train down. How do you decide which track the train should go on? Obviously, that seems to have no implications on neurotechnology. So let's connect that. Instead of it being a train, what if it is someone sitting in a wheelchair, and the wheelchair is barreling towards someone? The wheelchair is now operated using some kind of AI. I guess my question to you, as you start pondering the question of neurotechnology and criminology, it hits someone. Who's responsible? Is it the person in the wheelchair, who presumably had very little control? Is it the wheelchair itself, which presumably is sort of agnostic to who it hits? is the people for being in the path of the wheelchair, or is it someone else? Because this is becoming a real problem as we start exploring autonomous cars.
So are we thinking about an autonomous wheelchair, or are we thinking about a brain-controlled wheelchair?
Let's start with the autonomous, and then we'll go to the brain-controlled.
The autonomous vehicles. So it's a sort of an autonomous vehicle. Those are difficult questions. Like one of the problems is that there's a problem that many people can be involved. So, for example, maybe it's not completely autonomous, and maybe the wheelchair user has got some kind of override capacity, and then also it's been created by some company, and then within the company there are various people that have had a role in the algorithm, and that's a very difficult and muddy question. I must say it's not the one that I've focused on. My focus would be more on the neurotech one, so the brain controlled one.
Interesting. I would have thought that autonomous was a type. Well, it's AI. So you take one step behind and you go neurotech. So talk to me how what is the rubric in analyzing a situation like that in the context of neurotechnology?
So the debates about neurotechnology overlap very significantly with debates about AI. So for example, you could have a neurotechnological device like, say, for a wheelchair that might try and predict the intentions of the user in order to sort of make it more usable in the way that Microsoft Word predicts text, and it uses a kind of machine learning type approach to do that. So these questions do overlap, but it raises an interesting question. Like, say the person drives the wheelchair into somebody and kills them. So let's think about it in a criminal context. You might think, well, what about gross negligence manslaughter? That's a crime. I'm not sure what the American, in your jurisdiction, the term
about right.
The term would be. Well, let's say there was some kind of device that was part of the offender's brain. It was implanted into their brain, and that device malfunctioned. So one way of thinking about it might be to think about it. Well, there was a defendant who had a device implanted in their brain, and they had no reason to think that it was going to malfunction. It did malfunction, so they're not grossly negligent. Another way of thinking about it might be, well, if it's integrated enough into them, then it's actually part of the defendant. So the defendant's no longer, the brain implanted defendant is no longer a person who's using a tool, but they're a cyborg who's partly organic and partly inorganic. Then on that view, you might think, well, they malfunctioned. And so, they didn't meet the right standard, so maybe they're grossly negligent. So it sort of raises an interesting question about where does the defendant end and where does technology begin, which I think is a sort of interesting question for the criminal law. Is it somebody using technology, or is it a cyborg that's partly technological?
It's a really interesting question. You sort of hinted at it and then moved to the right, which is you talked about, did the technology malfunction or did they malfunction? Now, the closest corollary to that, as I see it, is the idea of mental incapacity, and to say that if I injured you, but I'm mentally incapable of understanding that I did that, the solution is not sending me to jail. The solution is sending me to a hospital and having me be fixed. or maybe I don't know if the right word's fixed. The right word's probably cured, or at least resolved in some way. But the point being, in either scenario, the idea is I should be taken out of general society, my problems to be addressed and reintroduced back into general society faster than if I had free will, if you will. You want to say something before I go to the next part of that question, or
no, go on, keep
okay?
going.
I guess my question is, in a situation like a quote unquote cyborg, is it appropriate to take the person, get the technology fixed? Maybe it's just replacing the actual technology, addressing the actual concerns, whatever it is, and then introducing them back into society. And if so, it seems like it would go to the central point of what you described as integrated enough. How do we define integrated enough?
Just to go to I'd like to just say something about the first point, because okay, so we've got the mental illness defense, sometimes known as the insanity defense in some parts of the jurisdiction. And if a defendant is successful in putting that forward, then they go into a therapeutic regime where the aim is not punishment, but it's sort of a therapeutic aim to get them better. But in order to get into that therapeutic regime, the person's got to satisfy the McNaughton test. So they've got to not know the nature and quality of what they did, or if they did, they've got to not know it's wrong according to standards of ordinary people. Now, it's not clear that this wheelchair situation we described there, the person would fall into that way of getting into the therapeutic regime. So if we are going to, if the idea is, okay, well, they are a cyborg, they need to be fixed, well, that seems to require some kind of redefinition of what takes you out of the criminal justice paradigm and into the therapeutic regime, because the current way of getting into a therapeutic regime doesn't seem to fit it.
I agree, which is why I love pondering these questions with someone as smart as you, because then I get to play around with the concept and see what pops out. Is there any thought process around what integrated enough means?
Well, so I sort of briefly raised this question I wrote a paper on brain-computer interfaces and the revenge porn offense. It's called Neurobonic Revenge Porn. And so it's a sort of striking title. So if you Google that, you can find the paper. But I got a reply from a philosopher called Kramer Thompson, and he discussed this question of what might adequate integration be a bit more. And so I think, as I remember, what he said was, if you think about something like a bit of technology like a map, a traditional map, a paper map, you hardly ever consult the map. You consult it once in a blue moon when you're a traditional map, when you're trying to find somewhere. So that's not really integrated into you. Something like a smartphone, you're relying on that a bit more. It's a bit more kind of part of the way you remember things and that kind of thing, and that might be better. And then if something is kind of you're using it all the time, and it's really part of almost become part of your ordinary thinking process, then that might be integrated enough. I haven't really done that explanation justice, but it is something that people are thinking about in this context. So there's some philosophical work on what it might be for a bit of technology to be integrated enough for it to count as part of you. I think the philosopher Andy Clark, a sort of big name philosopher, he's considered that question. But I guess so I just touched upon it. I just raised it in my paper. I didn't try and answer the question of what's integrated enough. But I think an interesting point for the criminal law is, and other areas of law, is that they might have to do that. There might need to be some case law. If a defendant says, "Well, that was just a tool I was using,"
yeah,
the prosecution think, "Well, no, you're not. You're kind of this is integrated into you," and they might want to make such an argument to say, "You can't just blame the tool. You failed here," and so that would force the development of the common law.
Here's a weird question for you.
By common law, by legislation, but sorry, can I?
No, do you think that the distinction between ethics and law is if the courts have had a chance to rule on it?
The distinction between ethics and law, yeah. I mean, that question is, it's a big question in legal philosophy, isn't it? Like, and to what extent are these two connected or different? And some views are very different, and some are there's a closer connection. I mean, one of my friends who appears in the High Court here, which is the top court, and he thinks the higher up you get up in the court hierarchy, particularly up to the High Court, the more receptive the courts are to an ethical argument, because the laws run out, and that's why the case is up there in the High Court here or your Supreme Court, because the laws kind of run out of it. So maybe down in the lower courts they are a bit more separate than in the higher courts. I mean,
very interesting. As usual, Alan, we start having fascinating conversations and then we run over on time. This is one of those times. We're already at 28 minutes, and as you know, we aim for about 15 to 20. So before we go, I have 4 questions to ask you. My first question is, well, first of all, let's remind everyone where they can find you, and that is amcc4688@gmail.com. Is that correct?
That's right.
Perfect. My second question is, based on what we've discussed, what is something you'd like to ask the audience?
So I was going to talk a bit more about neuro rights, but I think the question I'd ask to the audience is how should emerging neurotechnologies be regulated? So what should regulatory bodies, for example, and legislatures be doing to try and make sure that neurotechnologies develop in a responsible way?
Let me start by, like I told you, I always try to answer the question first to see if I can at least be the first person to answer it. I think the way you would start is by defining what integrated enough means. I think without answering that question, the rest of the answer is a lot easier. Because if you answer that question clearly, then the moment you become a cyborg is much more easily defined. And therefore, everything criminology-wise is much clearer. Until that point, it's more of a device-solving problem and not a person-solving problem. So I think if I was king of the world and I had to define what the appropriate solution would be, I'd start from that question, because that, to me, falls at the crux of the entire problem. Have you seen it done differently? Or have you? I know Chile is doing something different, so what's your thought process there?
Well, the Chilean thing's a bit more general. It's not looking at the specific troubles that the criminal law might have. It's a bit more like looking at the question, well, how do we regulate neurotechnology? You know, we saw what happened when social media went kind of wrong, and neurotechnology could also go wrong, and they're trying to work out some principles for how neurotechnology and the development and its use should be governed in a more kind of general sense. And so that's really what they're doing at the moment.
Let me ask you two other questions. What is something you've learned in general over the last month that you think my audience would love to sort of hear?
So I've been I did a interview for a Romanian radio show recently, and the presenter of the show drew my attention to a school of thought called Russian cosmism, which I hadn't heard of before. But so you might think of it in Silicon Valley. They've got, you know, people like Elon Musk and Ray Kurzweil that have got a kind of transhumanist thinking. They think we should enhance our capacities and maybe compete with AI and that sort of thing. Whereas there's a specifically Russian kind of thinking that's got something in common with transhumanism, but it's not the same. And so I've enjoyed reading a bit about this sort of somewhat transhumanist thought in Russia.
Oh, I definitely have to look this up. This sounds fascinating, because I'm kind of fascinated by transhumanism. So to know that there's a totally different school of thought sounds fascinating.
Yeah.
What's something that made you happy in the last week?
Well, unfortunately, we're in lockdown here, so the thing that sort of made me happy is luckily it's quite sort of sunny, and there is you know, I walked down to the Opera House yesterday at Sydney, and that's a lovely walk, and so that kind of cheered me up as I wait for things to improve on the health situation in Australia.
I visited Sydney only once, but I love going by the rocks to the Sydney Opera House. So it's gorgeous.
Yeah, it is.
Well, as always, Dr. McCay, it was wonderful to have you on, and I do hope you'll consider coming back.
Sure.
And just want to say thank you to the audience, and we'll be back soon. Stay tuned.
Thanks very much.
Thank you.